The instance where a domestic violence victim does not want to pursue the charges against the defendant is probably the most common situation that you see when someone is accused of a domestic violence charge. Okay? Maybe the numbers are as high as 9 out of 10 people who are victims of a domestic violence offense, who are at least listed victims. Probably 9 out of 10 of those folks are going to want to have the charges dismissed or dropped, are going to not want to participate in the prosecution. It is extremely, extremely, extremely common. In fact, it is the rare case where the victim does want to prosecute after the person has been charged with a domestic violence offense. It is extremely common. So pressing charges by the victim is not required. This is another major confusion that most folks have. The victim does not have to quote unquote press charges. The government is the one that presses charges. And in most locations, in most jurisdictions, they have what could be called as a pro-arrest policy. Police show up to a domestic violence scene, and if they are told any facts that could amount to a crime of domestic violence, well, somebody's going to likely be going to jail, okay? Whether the victim wants them to go to jail or not, whether the victim sometimes is even begging the police, please do not take this person to jail. The victim does not have to be participating in pressing charges. And similarly, the victim doesn't have the power to drop the charges at a later date. This is also another area of massive confusion. To get the government to make the choice to listen to a victim who doesn't want to press charges is something you need to be working with a lawyer about, okay? The lawyer, you want to get yourself a local lawyer who does criminal defense and practices involving family violence cases. That lawyer is going to know how to get the government to listen to the victim, whereas the victim themselves just doesn't have the power to drop the case and will be likely unsuccessful in their attempts to do that. So if the victim is uncooperative in a domestic violence case, let's say the victim maybe tries not to go to court or things like that, what the prosecution will do is two very important things. They'll likely subpoena that victim, meaning that if the victim doesn't have a choice whether they come to court or not. If they fail to show up when they're under subpoena, they'll be subject to arrest. So that's one technique. Other times they'll get the victim there and the victim simply doesn't want to say things that are bad for their loved one because, again, they're not supporting the prosecution. So what the government likes to do in those situations is simply to play for the jury the video of what the victim said initially on scene when the police showed up. So in other words, victim will say ABC on the stand today, but on the video the victim was saying XYZ. And they will play that for the jury. It's called impeachment. And the jury will be left to decide, is the victim telling the truth today when they've said ABC, or was the victim telling the truth back on the day of the event when they said XYZ? In some ways, I think it can be, frankly, worse evidence, meaning for the defendant. It can be better evidence for the government if a victim shows up to court and says, no, nothing happened, and it's not believable. Frankly, that's, I think, more damning against the defendant than if the victim showed up and was still fired up to try to get, the defendant and was claiming the same thing they said initially. I would rather have that person as a witness to cross-examine than somebody who's patently lying for the defendant now. So, yeah, it's just a super common technique. They'll play the video, and frankly, juries usually will credit their initial statement to the police that's on video and not the testimony at trial. It's an art form to try to get through these things.